We are joined now by Devon Carbado, professor of law at UCLA and author of Unreasonable: Black Lives, Police Power, and the Fourth Amendment. Devon, thanks so much for being here today.
Not at all. It really is my pleasure. Thank you for having me.
I'm looking forward to our conversation. So part of what I loved about your book is that you do not treat the Constitution as a religious text, pure in its intentions and pure in the outcomes that it tries to realize. That's a pet peeve of mine in American discourse, where it's like the Bible. I think at best that's an ignorant perspective. At worst, it's a racist one. I mean, talk a little bit about the structural, the Fourth Amendment in general, and why you chose to focus on it, and why, in your estimation, it's flawed in terms of how it sets up the police state in this country.
So there are a couple of ways to think about that. I'm sure if your listeners were asked to articulate the Miranda warnings, they would probably be able to do it, because whatever our views are of policing, we probably have our favorite cop show. So everyone knows the Miranda warnings, but people don't necessarily know the text of the Fourth Amendment. So let's think about exactly what the text says. It says we have a right to be free from unreasonable searches and seizures. And the basic idea is that this text was supposed to create some kind of boundary between lay people and the police. But for Black people, the Fourth Amendment operates more like a gateway. That is to say, it provides the police with access to Black bodies in a number of distinct ways. The easiest way to understand what I mean is, again, for a minute, to just focus on the text, just for a minute. Unreasonable searches and seizures. So what that means basically is if what the police officer does to you is neither a search nor a seizure, then the officer needs no justification. So if you're walking on the street, Emma, and cops approach you, question you, ask for permission to search, etc., none of that is a seizure. None of that implicates the Fourth Amendment. So what that means is that the government can do that, police officers can do that without any justification at all. That's one problem. The other problem is that even when what you have is a search or a seizure, the courts make it really easy for police officers to justify it. The classic example is stops and frisks. Stops are seizures, frisks are search, but you just need reasonable suspicion. If I were to ask you to guess, reasonable suspicion, what do you think that translates to as a probability? What's your guess?
Probably being Black, or as a probability. I mean, not being white, and being in the neighborhood where police want to rack up some numbers for their arrest records, for their quotas.
Fair enough. If I were to ask you to put a number to it, percentage, and we'll come back to the being Black part in a minute, I promise.
A percentage of what? I'm sorry.
Yeah, so what probability? So is it 50% likelihood of doing something wrong? Is it 20% likelihood of doing something wrong? What is reasonable suspicion
for what constitutes it in practice? Yeah. Probably what, 10%?
Probably around that. So it's a really low bar. And part of what the court has said with respect to interpreting reasonable suspicion as well is that if you are in a quote unquote high crime area, that gives cops, that is a factor on which cops can rely to say they have reasonable suspicion. So just being in a quote unquote high crime area, we know what high crime area means. It's code word for Black or brown community.
Right. And so just being in that area is enough to create reasonable suspicion. The reasonable suspicion standard that you mentioned, talk about Terry versus Ohio and how that's set up. Maybe it goes back further than that, and you can correct me if I'm wrong, but you cite this in your book. The concept of reasonable suspicion, which also paves the way for stop and frisk. We film here in Brooklyn. We're intimately aware of stop and frisk policies in New York City. What did that decision do for those kinds of police procedures and conduct?
Sure. So I'll back up just a bit and say that with respect to what counts of reasonable suspicion, just to be clear about it, the court says if you are in a high crime area, A, and you're fleeing the police, B, that effectively is enough to give the officer reasonable suspicion. So just think about what that means. But to go back in time to 1968, just think about what's going on in that particular moment. A lot is going on in 1968 in America. The Supreme Court is called upon to determine the constitutionality of stops and frisks. And the person who actually writes the opinion is Justice Warren. Why is that significant? Because Justice Warren is the person who also authored Brown versus Board of Education, the famous case that, of course, declared that separate but equal is unconstitutional. And what Justice Warren does in that case is to say, look, we are effectively going to allow police officers to stop and frisk people. I'm simplifying the ruling a little bit, to stop and frisk people without probable cause. So probable cause is thrown by the wayside, and reasonable suspicion becomes the standard for police officers to stop and frisk, which means it's a low evidentiary hurdle for cops to have. So that is the birth of stop and frisk in constitutional law.
And what that decision, was it unanimous or nearly unanimous? I mean, can you talk a little bit about the historical context of that decision? Because obviously, that's an era of civil rights, lots of change a little bit after that, but the court had gotten a lot of, I think maybe now contemporarily gets a lot of credit for some of the decisions that they landed on during that time period, but this one has not aged well.
This one has not aged well. And there are a couple of ways to think about it. So Justice Marshall actually signs on to this opinion.
Yeah.
I mean, he's a part of the justices who say, we've got to do this. And remember, this is a moment in which there's the rhetoric about law and order already emerging, and the sense that we have to do something to control expressions of civil disobedience, to control, again, what people perceive to be unrest more generally. And this was the way in which Justice Warren negotiated that. Now, just a year or so later, Marshall quickly peels off and says, I can't believe we did this. Look what reasonable suspicion now means. But he is a part of the group that says reasonable suspicion is going to be enough to justify stopping and frisking people. Fast forward to the Floyd case. You know a lot about the Floyd case. It takes place in New York, where the question becomes whether the NYPD is violating the Constitution, and Judge Shara Shindlin concludes that, in fact, there is a constitutional violation, both under the Fourth Amendment and under the 14th. And that was kind of a remarkable moment. And many people concluded from that somehow stop and frisk have been abolished. They've not been abolished. It's still perfectly constitutional for police officers to use stop and frisk, again, based on reasonable suspicion. The problem for Judge Shindlin was that New York police officers didn't even have reasonable suspicion. So her quarrel with the NYPD was around the fact that they were stopping people, frisking people without reasonable suspicion. And some of the data that I should give you a sense of might be helpful. So between 2004 and 2012, there were 4.4 million stops. That's a ton. Only 12% of which, only 12% culminated in arrest. 12%, think about that.
So that, yeah. So, I didn't mean to cut you off, but that lends credence to what people understand fundamentally if they've listened to this show, but that it is a vehicle for harassment as opposed to the actual outcomes that are said to be being sought.
Precisely, and to underscore that point, 52% of the people who were 52% of the people who were stopped were also frisked, and wait for it, in only 1% of those people did they find weapons. So again, they're not finding weapons, they're not arresting people. It's a programmatic project of discipline and social control rather than a serious law a serious investigatory tool to solve crimes.
So now here's like the bigger question about that, and we can return to some of the different ways that policing exploits the Fourth Amendment. But is it not just is the system of control inherent to the Fourth Amendment, or do you believe that it was bastardized in order to fit into our, white supremacist police state? Because to me, I think the subjectivity inherent in the text, I lean more towards the former.
So there are a couple of ways to think about that. One is to first take the historical perspective and ask, so who was the Fourth Amendment intended to protect? So remember, the Fourth Amendment is added to the Constitution in 1791. So it's part of the Bill of Rights. Why is that significant? It's significant because in 1791, we're talking about a slave constitution. We're talking about a constitution that legitimized and anticipated slavery. That's the A part. The B part is it's also a constitution that imagines that Black people will be recaught by slave masters without any due process at all. So one could say, against that historical backdrop, that the Fourth Amendment is working the way the Fourth Amendment was supposed to work. It wasn't intended to protect Black people. I don't think that's a particularly controversial argument. And indeed, what you could say, if you're an originalist, you should understand that originally the Fourth Amendment was not intended for us, where us means Black people. Again, shouldn't be a controversial argument. Now, having said all that, you and I both know that constitutional text, when you read the text, are not self-executing. By that I mean you add value to them. And part of the ways in which I demonstrate that particular point in the book is through chapter 6 and chapter 7. So in chapter 6 of the book, I have the readers engage an opinion called Wren versus United States. So this is a unanimous opinion in which the court actually constitutionalizes racial profiling. And let me be clear about what I mean by that. So let's say the police observe me driving down the street of Los Angeles afternoon as well. Both of us are driving down the street of Los Angeles. There's no dispute about that, trafficking. But they realize they can only stop one of us. So Officer A says to Officer B, let's stop the Black person. And to avoid any confusion, I will be the Black person, not you. So they stop me in this particular moment. And the question becomes, is that constitutional? The Supreme Court says yes, under the Fourth Amendment. Why? Because the officer had probable cause to stop us. So the fact that the officer chose to stop me based on race doesn't matter if the officer has probable cause. Again, a unanimous Supreme Court, including the great late Ruth Bader Ginsburg, co-signs this, right? So that's a very clear moment in which racial profiling is being constitutionalized. And why that matters. So this is the only piece of legal advice I will give, which is this. If you drive your car, you violate a traffic code. You cannot drive without violating the traffic code, which means that it's easy for police officers to stop you anyway. And now they can stop you on the basis of race, consistent with the Fourth Amendment. So I have the readers read that particular opinion so they can get a sense of the ease with which Black lives can be disposable in the context of constitutional law. And then I have them read the next chapter, which is my rewriting that opinion in a way that comes out differently, to say that you can read the Fourth Amendment, notwithstanding its history, to actually make Black lives matter more than they currently do in the context of law. So it's a nice juxtaposition in the sense of saying that's what the court did. It wasn't inexorable. This is what they could have done. Read it. Tell me if I'm crazy.
Well, Ruth Bader Ginsburg did seem to have somewhat of a blind spot when it comes to race. I think, that this opinion not aging well is a bit in keeping with her history, which is, like many people, complicated. But I am fascinated by the you mentioned about if you were an originalist, you would have the context that you then describe about the Fourth Amendment. Um, can you expand on the notion of, and this is a bit of a larger question, I apologize if it's a diversion, the Constitution and amendments like the Fourth Amendment being there to protect property owners, in particular, men that held property, which at the time included slaves, and how that is just so inextricable from the context that we're living in today in 2022 when looking at this document?
I mean, I think the bottom line here, I think, to be somewhat simplistic about it, is that originalists tend to be selectively originalist. By that I mean, they're not originalist about the original sins of this nation vis-a-vis its racial and gendered projects. I mean, it's absolutely uncontestable that our constitutional history is rooted in sexism, is rooted in patriarchy, is rooted in racism, and that's there. People do make arguments about the extent to which the Reconstruction moment fixed all of that. But it's after the Reconstruction moment that we get Jim Crow. So it's unclear how one can mark that moment as a fix to a racial project when that moment becomes its own new racial project. And one of the ways I sometimes think about this with respect to questions about racial justice is to sort of think about it in 7 days. And at the end of which there's kind of a multiple choice question. So in day one, there's no dispute that group A has been enslaved. Everyone say, yeah, that happened. Day two, let's just say slavery ends, at least formal chattel slavery ends, but there's still an afterlife of slavery. There's no compensating group A for the fact that they were enslaved. None of that, but anyway, slavery ends. That's day two. Day three, group A is now Jim Crowed. Everyone agrees that that happened, subject to constitutionalized, legalized racial segregation. That's day three. Day four, there's no compensation for that, but at least you have Brown versus Board of Education, which says you can't have racial segregation in the context of schools. Day five, there's massive resistance to Brown versus Board of Education. Segregation today, segregation tomorrow, segregation forever. You have intentional discrimination everywhere. You have violence preventing Black people to vote. All of that is happening. And then you have day six. You have civil rights intervention, the second Reconstruction, anti-discrimination law. And day seven, the same group A is over-incarcerated, underemployed, overrepresented in homelessness, circumscribed access to the ballot, underrepresented in political leadership, underrepresented in educational institution. And the multiple choice question is, why? Answer A, there's something wrong with group A. Answer B, it's just chance that group A's history happened, but it's not playing a role with respect to what's happening to group A now. Or answer C, it's because of a racialized history why you see this. I pick C. Now, you can have a fight about it, but it seems to me that the basic way to understand contemporary forms of racial inequality is to tell that 1 through 6 story and get people to pick a fight with you. So what are you going to fight with me about? Which day did I get wrong? It's hard to say that I got any of those days wrong, I think, unless I'm missing something.
No, you didn't. I mean, and I mean, frankly, it's just willful ignorance to ignore those kinds of steps, and we do not have the requisite historical understanding in this country, I think, for a lot of people to deal with that. But I mean, you know.
And at the same time, not to interrupt you, we're trying to close down conversations about that history before we even understand it.
I mean, that's absolutely correct, and that's purposeful, frankly. I want to take a bit of a turn because you talk about the structure of policing in your book, and you identify seven different levels of policing in this country. Can you dive into those levels and talk a bit about them?
Sure, and I'll precisely because you're not reading the text and people are listening, I'll make it slightly less complex. But the basic idea is this. In thinking about problems of police violence, the first question you might ask yourself is this. What are the forces that create the possibility for police officers to interact with Black people to begin with? And the reason one wants to ask that question is this. Repeated exposure to the police creates the possibility that they can harm you. If you're not having contact with the police, they can't stop and frisk you, they can't kill you. So a central question is, what are the factors that puts African Americans in front of the police? I argue Fourth Amendment is one such factor. So that's one important structure we need to think about. Another important structure has to do with police culture, police trainings, police unions. If police culture encourages violence even implicitly, then clearly you will see violence. If police trainings don't attend to problems of violence, clearly you will see violence. And if police unions are much more interested in, say, protecting police officers and holding them accountable, again, you'll see violence. Another crucial question that we sometimes don't think enough about is this. What happens when police violence interacts with the legal system? By that I mean, there's no dispute that someone's been brutalized, no dispute that someone's been killed. What now happens when one brings those facts in front of the legal system? What are the outputs? One output is justifiable force. Police violence plus the legal system equals justifiable force. And there are a number of ways in which your listeners, I know, have seen this. One is prosecutorial decisions not to bring charges. Someone's been brutalized, someone's been killed, but the prosecutor says, I'm not going to bring charges. That's a justifiable force moment. Or the prosecutor brings charges, but the grand jury says, we're not going to issue an indictment. That's another moment in which police violence, legal system, justifiable force. Or prosecutor brings charges, grand jury issues an indictment, and a judge or a jury says, no conviction. These are all moments in which police violence, fact, enters the legal system and comes out as justifiable force. That's one problem. Another problem, of course, is qualified immunity. I'm not in this moment going to get into the whole of qualified immunity, because if I do, you'll be saying, come back, Devon, come back, and I won't be able to. But the point is that everyone understands that qualified immunity erects a really high bar to holding police officers accountable. Everyone kind of gets that. The debate is whether that's a good thing or a bad thing, not whether it's a thing. The problem is even worse in the sense that assuming you jump the qualified immunity hurdle and you win a lawsuit against a police officer, assuming you do that, who pays the damages? Not the police officer, your tax dollars. Cities and municipalities end up paying. And finally, try suing a police department or a city for acts of violence in which its officers engage. You will not win. That is an impossible project.
Well, you mentioned, sorry to cut you off, but Breonna Taylor's, the money that was paid to her family is a great example of that coming out of the coffers of the taxpayer, as opposed to, the police department being held accountable. Continue, I apologize.
And you can have, and there are lots and lots of examples of just that point. The disparity is quite staggering between what police officers actually pay and what cities and municipalities pay. So we are paying for police violence is the way to think about it.
And this, we're experiencing this in real time in the fallout from the Uvalde massacre, where you see the police department got 40% of the town's budget in Uvalde. And it seems that they are dodging or attempting to cover up something because their story has changed around a dozen times about what actually went down when there was the active mass shooter inside of that elementary school. And I'm a bit frustrated because it feels like we're still having the same conversation and Republicans are already saying police need more funding when they were incredibly well funded. There were tens of police officers there with as much gear as they could possibly imagine, and it still seemed to do nothing, and they're still lying and hiding from investigators within the state of Texas. Why do you see? I'm curious about your thoughts about what's happening in Uvalde, but two, why is there this persistent desire, seemingly from a lot of the public, to see these incidents as anomalies as opposed to obvious patterns?
So I want to answer your question not by talking about that particular moment in a way, because we have more information, more data that's available to your listeners and that I would encourage them to take a look at by way of Ferguson. Why do I say by way of Ferguson? Because Ferguson ended up producing a Department of Justice report. And that report is a must read. Why? Because it reveals the extent to which racism and classism were bureaucratized as ordinary features of governance. By that I mean, the report reveals the degree to which policing was employed as a revenue-generating mechanism and ended up funding 20 to 35% of the city's budget. So you see how this ties into the question that you raised. We have that data. We know how it operates, where people issue fines. People are issued fines, right, that they can't pay. So the standard way in which this worked was something like this. You get a warrant for something ridiculous. You show up, let's say, because there's a mandatory court appearance. You can't afford to pay. What happens? Well, maybe you get arrested in the spot, or you get a higher fine, or plausibly, you get your driver's license revoked, and then you drive without your driver's license and you're arrested. I mean, all of this resulted in a regime of social control where people would find themselves fined, arrested, incarcerated, can't get out of jail because they have no money to post bail, and the collateral consequences of all of that. So it's implicated not just police officers, but a system of governance writ large, which is why it's a mistake to have a conversation about policing that focuses on whether individual police officers are engaged in individual acts of violence against individual Black people. That's not the way to think about it. We should be asking ourselves, what are the sources of police power? How are those sources implicated in government? And how can we peel away at those particular structures?
You mentioned how the traffic stop dynamic, and how the more interactions that you have with police, the more likely you are going to be a victim of police violence, etc. What is your sense about the and I guess, what did you study and research about the legal basis behind traffic policing? Because, frankly, it seems like if we want to defund the police and restructure them, which I do, traffic cops and having police with guns there to stop somebody for a traffic violation should be one of the first things to go. What is some of the legal precedent that has led to that being such a large part of police work? And how does that get detangled or untangled?
The precedent is very much the case that I referenced earlier, and I only told part A of the story about that case. Again, the Wren versus United States case. Part of what that case does as well, to be clear, it suggests that officers can use traffic stops as a pretext to investigate crimes for which they have no probable cause. So again, remember what I said earlier, that if you drive a car, police officers can find some easy way to stop you because you're going to violate a traffic code. I mean, that's just going to happen. And I should be clear to give you some examples of some of those violations. So tell me what this means. Driving left of center on a grade or a curve. I don't know what that means. Driving too slowly, following too closely. I mean, these are all predicate bases on which an officer can stop you. So the officer can stop you. You drive, you can get stopped. That's the A. And the officer can now legitimately investigate some other crime for which the officer has no probable cause. If the officer stops you for driving left of center on a grade or a curve, if the officer stops you for that, the officer can effectuate a full-blown arrest for whatever that is, which we don't know what it is, but whatever it is, the officer can arrest you for it. If the officer stops you for that, the officer can ask you to get out the car, just willy-nilly. If there's a passenger in the car, the officer can ask the passenger to get out the car. I mean, so part of the story I tell in the book about traffic stops is the way in which they can function as gateway seizures. So people need to understand all the ways in which traffic stops can expose people to more intrusive encounters and ones that can culminate in death. It's not accidental, or shouldn't be surprising, that some of the episodes of police killings have as their starting point a traffic stop. Shouldn't surprise us. And so thinking about the source of police power then in the traffic stop context is crucial. So I agree that peeling away that power would be an important move to make.
How do you feel about, we're talking about gun control in this country right now, and it's something I'm 100% in favor of, and I can't speak for you, but I think many people are. It's quite popular, banning assault rifles, among other things. But you talk about how the Fourth Amendment has been so abused by police in a racist way, targeting Black people, other non-white groups in this country. Do you feel that there's a tension between some of those calls for gun control and how that might fall on non-white members of American society if that were to come to pass?
Say more about what you mean by that. If in other words, how gun control would affect
Say there's some sort of searches and seizures and weaponry that would be targeted. Would that lead to more police power structurally that could be used in order to target Black people in the country?
I mean, my views on gun control are pretty mainstream. I mean, I think most people think that we're kind of out of sync with respect to the degree to which people can access guns and the kinds of guns that are floating about every day in our various neighborhoods. I mean, I think so. So the gun control thing, I don't fully get why it's such a hard nut to crack, but I really, as a foreigner, I mean, I don't completely understand that, but it's something that is hard to make progress on, again, for reasons I don't fully understand. The only thing I want to say about the gun control issue as it relates specific to the Second Amendment takes us back to a point about law and legal consciousness in this sense. And think about what could happen to Roe v. Wade, what likely will happen, or how that will shake out. People on the right make Supreme Court cases a project. They talk about them, they mobilize them in their political organizing, and they change the law. The Second Amendment now was not what it was 2 decades ago. People on the left, not so much. I mean, we don't have our cases that we lift up. We don't. Who talks about Wren versus United States? Like a case that constitutional. I mean, who knows that case? Who knows that in order to bring a discrimination suit against the government, you need to prove that someone acted intentionally against you? Who's going to prove that? So solving racism by way of finding a bad actor. I mean, how much dismantling of racial inequality is that going to perform? Who's marching saying this case is crazy? Meanwhile, conservatives have their cases, their projects that build on legal consciousness to stage social movements. And I think the left is behind on that score.
I'd love to, Fair enough. I mean, my question was really just about how, some of the gun control measures historically, were targeting Black Panther members. I
Yeah.
want us to be, and it's a bit beyond the scope of your book, I understand, but intentional about not using these measures to further embolden police, give them more resources that they can use to crack down on non-white people in this country.
Yeah, I think that there's always a way in which particular kind of rights are asymmetrically dished out. So from rights to citizenship to rights to gun, whatever the right is, Black people are not going to have it in the same way that white people. I mean, that's like my starting point. So, and one can think about that across every dimension. And indeed, even if we think about reproductive justice and reproductive rights, I mean, the right to that Black women experience very differently than white women, for example. So I think any right you name, I will say there's an asymmetrical arrangement with respect to people's ability to access it. And guns are no different in that regard.
Absolutely. I wanted to touch on the point that you just made about how the right has their hobby horses, for lack of a better phrase. They have their Roe, they have their Casey, they have their Supreme Court cases that are the targets that they use to galvanize voters. But more importantly, in my opinion, they have legal apparatuses, or they have groups that like the Federalist Society, other ways that they're stacking the courts with judges who are going to put forward their agenda. And so, as you say, the left doesn't have that, but there are some hopefully that the Biden administration is doing a good job in this regard. They are confirming federal judges at a rapid rate.
Yeah.
And we need more of that,
Goodness.
frankly.
I mean, let's just go. I mean, right. Just think about the past opportunities that were missed.
Right.
And the degree to which this was just not a project. I mean, not a project. I'm thinking about, you've got to have justices and judges who are going to think about law in a liberatory, egalitarian way. Imagine that. It's controversial to want judges who are going to be egalitarian about the Constitution, that is somehow an issue that one needs to fight for. But it wasn't the case, or it hasn't been the case, that the judiciary has been a focus of people who hold egalitarian principles. It's been an issue for people who, think that, the Constitution should be interpreted in ways that deny people freedoms.
Yes, and so that I think that we're a bit Johnny-come-lately on that front, unfortunately, and I don't know how many rights are going to roll back in the decades that we're going to be catching up to that time period. But I guess I was curious of what you made of the right's ability to prioritize their agenda in the court system, and how what that means for the next few decades, as I say, the future in this country, where we're now playing catch up.
We are playing catch up, and I think we need to think about that playbook that has put us in this particular position. And there are a couple of ways to take up that question. If we remind ourselves, for example, that the Supreme Court is not the only game in town, that there are other spaces for law reform, recognizing that law reform isn't the only answer, of course, but it is one place to effectuate some kind of change. Then one can take a bottom-up approach. I mean, think about where we landed with respect to something like marriage equality. Marriage equality didn't start at the Supreme Court. It started at people pushing, their employers to do something, and then city government to do something, and then state legislators and state courts to do something, and then the Supreme Court caught up. So it reversed the order of change, if you like, by making it a local set of interventions that percolated up in a particular kind of way. And I think there are a lot of ways in which one might have to think about that kind of strategy vis-a-vis a range of social justice questions, not to see the Supreme Court to reign. I don't believe that, can't give that up, but to think about other avenues for specifically focus on law reform, again, with the big caveat that this is not the only or even the most important game in town, but recognizing that if you're in this particular space, that it's not just about the Supreme Court.
Well, Devon Carbado, professor of law at UCLA, author of Unreasonable, Black Lives, Police Power, and the Fourth Amendment. We will put a link to your book in the description. If you're listening on a podcast, it will also be there, and at majority.fm. Devon, thanks so much for your time today. I really appreciate the discussion.
I appreciate it. Thank you very much. Take care.
Thank you.